It's finally over, the longest mischief trial in Canadian history, the trial of Tamara Lich and Chris Barber, and charges laid against them for their involvement and allegations made during their participation in the Freedom Convoy protests in January and February of 2022. You're gonna have to excuse the noise, there's a heck of a lot of traffic, and I don't have noise canceling earpieces in, but maybe I should and learn from our friends at the CBC over yonder and follow suit. But so today, it's finally over. The trial's over. The decision, it's a long way away. As I understand, the judge has up to 6 months to render her verdict. This is a judge-alone trial, so it will be Justice Heather Perkins McVeigh of the Ontario Court of Justice who will render a decision in this case on each of the charges against Chris and Tamara. And she'll also simultaneously, I believe, at the time of her verdict, deliver her decision on the Carter application, where the Crown is trying to tie evidence against one of the co-accused, Tamara Lich, to the evidence of the other co-accused, Chris Barber, and vice versa. And to do that, there's steps they have to take. They have to prove the common unlawful design, as we talked about ad nauseum. The common unlawful design in this case is something that's not unlawful. It's not drug trafficking. It's having governments end mandates, and that's a legal purpose. So from the beginning, we're at an unprecedented territory in the Crown's Carter application to try to make something that is lawful into a common unlawful design. It seems like a non-starter to me, but that decision will be rendered assumably at the same time as the verdict. Now, it's not until this matter is now being adjourned until November 26th, 2024, courtroom, I believe, was it 14 or 7 at 1:45 in the afternoon for it to be spoken to, so that the judge can update the counsel teams as where she is in the progress of making her decision on the verdict as to the guilt of Chris and Tamara. Or the innocence, of course. Now, the Crown bears the burden of proof. They have to prove beyond a reasonable doubt that Chris and Tamara are guilty as of the charges as filed. So far in this court, in this case, this historic, extremely lengthy mischief trial, we have heard evidence of fumes invading buildings, of horns, of unsanctioned dance parties, to quote former assistant to Mayor of Ottawa Jim Watson, Mr. Serge Arpin, when he says they're having unsanctioned dance parties. Can you imagine, folks? Put yourself in the perspective of an Ottawa bureaucrat, and there are unsanctioned dance parties happening on your streets. That is a disaster of unmitigated proportions. Then we heard other testimony of people who said that their businesses suffered losses, but then we come to find out that maybe they're comparing their numbers from pre-pandemic to now, or during that period. So there are other factors influencing what's happening. There are stay-at-home orders, there are lockdowns, there are all other circumstances that have nothing to do with Freedom Convoy. So we heard a lot of impact evidence. We heard about a guy who said that he and his son had to walk a kilometer in skates because Bronson was blocked up, and people were making fun of him for walking in skates. I'm sorry. Do you see that happening? This is Canada, folks. Right there in front of the Supreme Court on Wellington during the Freedom Convoy, we had the Freedom Cup of road hockey games, people loving it, being a community for the first time in years, and that's what the Freedom Convoy really was. It was a protest, and it was a community with a few unsanctioned dance parties. So we heard this kind of evidence. We heard Miss Zexi Lee imitate an air raid siren. You can picture that if you want to. I mean, it's as funny as it sounds. That's what we heard in this trial. We don't have videos of Chris and Tamara going up to people, beating on them, yelling at them, attacking them, ripping masks off faces. We have none of that. There's not any videos of Chris and Tamara going up to these people. And the reason I'm holding this, by the way, is because I'm trying to remember the name of the DeCare case. That's going to be mentioned in what happened today. But we don't have videos of Chris and Tamara going up to people. We don't have evidence of them saying, go hurt anyone. We have videos of them saying, stay peaceful. And 4 examples of Tamara Lich saying, hold the line, most of those examples in reply to somebody else. So what do we have here when we look at the big picture of this case? 45 days of testimony, of evidence, of arguments, of legal submissions. There's little here. There's nothing here. The burden of proof is on the Crown to prove beyond a reasonable doubt that the accused people are guilty of the crimes as charged. They have not done that. So the only option for the court is, reasonable option, if we have a system of justice, a system, and not just a legal system like some people will say with that, is to acquit these people. So we'll see how it goes down. It's hard to predict what the outcome will be. We don't know what the judge is thinking, but we have a little bit of an idea. We get a little bit of insight into her thinking, because today the Crown was doing their reply to the defense's arguments. The Crown had closing submissions, the defense had closing submissions, and now the Crown is exercising what's called a right of reply to the defense's closing submissions. Day 45, longest mischief trial in history, Canadian history for sure. Intimidation, counseling. So today, what did we hear? Well, the Crown attacked things that the defense brought up in their arguments, and in some cases Ms. Magus made the point of rising to object to say, actually this is just re-argument, this isn't reply. So the Crown was narrowly focused on a scope of issues. They brought up a series. You can always follow my coverage on the Bird Place to see what I'm talking about specifically, but the Crown was focused in on things like the comments from defense that there was no line before February 18th. They were focused in on the Justice McLean decision, where the Crown says that just because he said, you know, that excerpt we've quoted so many times, that the defendants are at liberty, remain at liberty to continue a peaceful, lawful, safe protest. That no, that wasn't an endorsement of the protest, that he said he was explicitly talking about horns. But here's the thing, folks. All those issues were alive to him at the time. This is just my thinking. In front of Justice McLean when that horn injunction was made. If he wanted to, he could have ordered an injunction against the illegal parking, against whatever else. He could have done that right there and then. The city sought a separate injunction to do those things, to enforce bylaws, but they never went through with it. So the lack of enforcement was on the responsibility of the city. So we have to take those comments, I think, somewhat at face value. The defendants remain at liberty to continue a lawful, safe, peaceful protest. That's what we have here. We're working with it. So they spent time attacking the defense's position on that. They spent other time attacking other things. They attacked the Crown's position. The Crown attacked the defense's position on Justice Mosley's decision, Canadian Frontline Nurses. They tried to say that the defense was arguing that because the Emergencies Act was whatever, that it's no valid, and the defense says, no, we never argued that. We're arguing specific paragraphs and specific portions of Justice Mosley's decision where he found that the Emergencies Act was in breach of Section 2B of the Charter and was not saved by Section 1, you know, reasonable limits that they always like to say, that it was basically, it's ultra vires, beyond the power of the government to have invoked the emergency proclamation, that it was not justified, and that it unduly violated people's rights. So the Crown attacked that, and Mr. Greenspun got at us at one point. He said, that's not what we were arguing. That's not what we were arguing. So the Crown seems to be trying to make something that it isn't. The judge is alive to a lot of this. The judge is alive. Ms. Magus started by mentioning the Decare decision, which is a recent Ontario Superior Court of Justice decision, where Freedom Convoy, Ms. Decare, I believe is her name, was acquitted in the Ontario Court of Justice of, she was one of the first people arrested on February 18th, and that acquittal was maintained days ago in the Ontario Superior Court of Justice, or maybe a few weeks ago now, late August, I believe. And in that decision, the justice said, I don't know, in the decision, the justice said that it was, that just because she was present on the 18th didn't mean she was guilty of, people may have been blocking the streets with trucks, they may have been honking, they may have been doing mischief, they may have been doing all these things, but just because she's there doesn't mean she's a party or principal offender to that. And then Ms. Magus argued, this is very relevant to this case, because that's basically what the Crown is saying. Because Chris and Tamara were there, they're responsible for this. Because they said a few things, they're responsible for this. But as it says in Decare, which is the binding piece right now in Superior Court, that no, the Crown onus is to prove that beyond a reasonable doubt the people are principal or party to those offenses, not just that they were present when they were happening, whether it happened on the 18th or not. The Crown also attacked, further on the Emergencies Act, that nothing changed between February 17th and 18th. They said that the police, nobody's charged under the Emergencies Act, that the police were using common law powers. Now, this wasn't raised, but I want to mention that it was explicitly mentioned by the police that they were invoking powers under the Emergencies Act to declare the red zone, which the Crown admitted in court, and to issue these threats to people, say, hey, you're violating the red zone, which was created by the Emergencies Act, therefore you'll be arrested for mischief. So how is that not using the Emergencies Act? You try and square that circle for me, folks. I bet you can't. But it seems like the Crown is basically making an argument from any position retroactively to suit their needs. And they said, you know what, even in the case that they did use the Emergencies Act to declare the red zone, it's okay, because at the time they were presuming that they were acting correctly. Everything's good, you know, from their perspective. And then they attacked the thinking of Chris and Tamara. They said the defense cannot tender evidence that was not led by the Crown as hearsay of Mr. Barber's interactions with Mr. Blonde, with Officer Blonde, et cetera, et cetera, et cetera. Meanwhile, you know, to basically say that Chris, you know, he's acting in good faith or slow rolls and all this, they're like, if it wasn't tendered by the Crown, then it's hearsay because they never testified, whatever. There's only one way, certain specific ways, according to Simpson and other cases, to get these things into the thing. But the judge is alive. She said, no, there's exhibits of these entire text exchanges these, a lot of this is in the evidence. So she said, I will consider everything in the appropriate weight. And there were some pretty intense disagreements, well, not intense, but pointed disagreements between the Crown and the defense, between the Crown and the judge today. At one point, the first Crown who rose was talking about how Mr. Barber indicated in his messages he's frustrated with police, no longer wanted to work with them, etc. And the judge was like, well, hold on, actually, a few messages down in that text message chain, he says, oh, I'm sorry, whatever, we still want to work together and all that. So the judge is very alive to the context. And then she said, I'm not going to single out any counsel team here, but it's very unhelpful for defense or Crown to say to me, look at the context of everything and then cherry pick. So she's very alive, and she's a very active listener. Justice Heather Perkins McVeigh, when the Crown would make an argument, she would get in, like when the defense was during their closing, and she'd say, okay, well, where is that? Or how does that mean that? Or I disagree. And she, at one point with one of these arguments, she said, I disagree with you. And I believe it was when the Crown was arguing the mens rea, saying that the accused constantly mentioned that they were going to be arrested. Chris and Tamara in different videos said, oh, I might be arrested soon, whatever. And therefore the Crown said, that proves they have a guilty mind. And the judge basically said, well, no, actually that's not true. I don't buy that argument. And then the Crown went on and said, well, in Remley, the judge found that, yeah, okay, if you know you're going to be arrested, it goes to your mens rea. And she said, well, that's being under appeal. And the Crown said, well, it's binding in the meantime. And that's interesting because actually it was Justice Heather Perkins McVeigh herself who acquitted Mr. Remley in that case. And now it was appealed to the Superior Court of Justice, and the Superior Court of Justice ordered a new trial. So this is there's different layers to this, but I have to comment that the judge has been professional. The Crown, I believe that, not the individual Crowns, but overall the Crown's prosecutorial decisions here have been politically motivated. There's no other way to look at a 45-day mischief trial other than politically motivated. This is not a case where we have video of someone getting in someone's face, yelling at them in their face, threatening them, bashing them, pointing things at them. This is not a case of that. This is a case of people saying, come to Ottawa, join us in our protests. We're not leaving, but we're peaceful. Everyone's going to be peaceful, talking about code of conducts, talking about other things, talking about the police showed us how to get in here and where to park. This is a very unique case, like Mr. Greenspan argued, that had judicial approval in the Justice McLean decision, the February 7th injunction, where he said that, remain at liberty to continue a lawful, safe, peaceful protest. And it's also one where there's police instructions where to park. And then the Crown attacked that too, said, well, actually, there's no evidence that the police wanted them to park for more than 48 hours. And there's evidence on Monday morning that the police wanted them gone. And the judges basically disagreed with that too, said, well, you know what? There was no, it wasn't said to anybody that, hey, you have to leave after this sign when they were coming in. So we'll see where things land. It's hard to predict, but thank goodness the longest mischief trial in Canadian history is gone. It's done with, and now maybe there'll be another trial order down the road, and we'll have to do it all over again. I hope not. What do you think, Chris? Do you want another one? No. He's nodding his head, and he looks horrified by the mentioning of a possibility. I am beyond horrified that could happen here. If it goes to appeal, one of the things they could do besides reversing convictions or acquittals is they can order a new trial. They can say, okay, I'm not going to reverse it. Let's just have a new trial because there's issues. And
the Crown has been appealing everything.
The Crown has been appealing everything 100%. No matter which way this goes, there will be an appeal, whether by the defense or by the Crown. How long are we at, Chris?
13:24.
So we're just about at the end. I think we mentioned basically everything. There's more specificity if you want to go over what happened in court today. Finally, it did end by 12:30. So it was about 2 hours. I will give the Crown credit this time. We started a bit late. We started around 10:30, we ended around 12:30, including a break. So the Crown's 2-hour estimate was on time. I was once asked by the Crown, can you say anything nice? So I will say the Crown was accurate in their time assessment for this particular day and this particular set
today only.
When you're a lawyer, even the defense has done this, and they give a time estimate, they say 15 minutes, it's going to be 30 minutes, it's going to be 45 minutes, it's going to be an hour. But the Crown was to this, and again, the judge, a very active listener, and what that means is the counsel will say something, the judge will ask them, where's a specific example of that? Or, can you tell me how? Or and it really gives you an insight into their thinking. They're the trier of fact, not only the deliverer of the sentencing, but the trier of fact in a judge-alone trial. No jury here. It'll be Justice Heather Perkins McVeigh that delivers the verdict against Chris and Tamara. That's where we're at right now. On November 26, 2024, we will get an update where she is in her decision-making. This is a big decision with an enormous amount of evidence and information in the record. It's volumes. It's boxes. Like it would blow your mind. Every video is transcribed. Just the amount of information here, and you can just only begin to imagine the amount of court resources and cost to taxpayers this has taken. You know, I actually asked, and I think I mentioned this morning, I asked the Canadian press and the CBC reporters, you know, it would be a really interesting public interest story to know the cost of this trial, and they said, oh, that would be impossible. Is that what we pay our media for? It would be impossible? I would like to know. In any case, that's no affront to anybody particularly. I think that you could find out what the cost is per day and then literally just multiply that by 45, and then also try to, you know, you can then try to hypothesize what the policing
that would be a
cost
start.
is. Yeah, then you have to weigh in what the policing costs. They've spent I would say thousands of hours on this trial.
Yeah, I've heard numbers like north of 5 million estimates.
Yeah,
but,
so
you know,
an estimate floating around is 5 billion, but I think that's just for court time.
Yeah.
We got to factor in how much time was spent on the investigations.
and not to mention how much time and energy and whatnot.
Monitoring Chris and Tamara.
Yes.
All their
And the
stuff.
cost to them personally and financially as well.
Yeah, so I think Chris said this morning that he's been away from home 45 days of trial, more than 100 days traveling, because he lives in like western Saskatchewan. So for him to come back and forth, that's a multiple day trip each way. It's like 3,000 plus kilometers or something like that to Swift Current from Ottawa. So 100 plus days wasted doing this. Tamara as well, coming from even further west in Medicine Hat, I believe, or wherever. It's a travesty. I'm glad that it's over, and I think I'm not going to blame individual attorneys, crowns, counselors. I will say that I believe the overarching executive decisions being made on these cases are politically motivated, and that if it was a different set of circumstances with a different set of offenders, this would not be 45 days in trial. This would be a case. Can we resolve this? Can we concede a couple things on one of these things? No, in this case, everyone's dug so deep into the ground, there's cement pillars for a 100-foot skyscraper, right? So that's where we're at right now. That's not normally how this works. There's a little bit of give and take usually, unless you're talking about something heinous, but that's not what this is. So I think that's about it. I've asked Chris to do a lot. Thank you, Chris. He's reprised his role as the guy behind the camera with his amazing camera work, kind of going back to what we did earlier in the year, last year at this time when we started this
Over a year
coverage.
now, yeah.
It's been over a year as of September 5th. It's been a long road, and thank you all for following us. We don't know when the decision's going to come. As soon as I know, you'll know. And November 26th, we'll get an update from the judge on the timeline. She generally has 6 months. Again,
And we'll go out on a siren like we start.
yes, thank you all so much for following along, supporting everything. You've been so generous, so interested, and it's important to get this out, to share, to see this transparency in our system. This has changed my life, so I appreciate it very much. And until next time, from Ottawa.